Good morning. Welcome back to my docuseries on how fathers can win their custody case. I am Father X. It took me 40 months, but I won primary custody of my son in family court. And now I want to teach you what I learned from the perspective of a father who did this, because I know that the system is rigged against fathers. We need to teach you how family court works so you have a fighting chance at being treated like an equal human being. In my prior video, episode 2A, we focused on filing petitions, the types of petitions, and on physical custody. Now, we will move to legal custody, orders of protection, and restraining orders, and the difference between temporary and final orders. Let's talk about legal custody. In your custody petition, you will ask for legal custody, which determines who gets to make the decisions in three primary areas: medical, educational, and religion. The times where legal custody really matters is if your child is really sick long-term and has many medical treatment alternatives, and you want to be the one who decides the best course of medical action. With education, maybe you want him to go to a school that will further his future career, and the mother is weak in the educational aspect of raising a child. Or maybe you want him to go to a religious school, so you need legal custody to make it happen. And these are all totally valid concerns. You have to fight for your opinion to matter. In general, I find legal custody to be meaningless if you are the non-custodial parent, because there are only a handful of major decisions over 18 years. In reality, if you are a non-custodial parent with legal decision-making authority and your kid is healthy, he goes to the pediatrician for routine visits. No major decisions here, and you don't get to raise your kid except on alternate weekends. So that's not good. For education, you may pick an elementary school and then high school, but then you don't get to see your kid except on weekends. So you may not even participate in his daily education. So that's not good. For religion, you can't really force the mom to go to church or temple during her parenting time, and it's hard to raise a child in your religion if he can only practice it on alternate weekends. So legal custody is often meaningless. So when this is offered to the non-custodial parent, I see it as a manipulation tactic to make the non-custodial father think the court values his parenting role. So be careful not to fall for this trap. Don't get me wrong, you still want legal custody, but what you really need more is primary or 50-50 physical custody. In my case, the mother and I have shared legal custody per court order. With major decisions, we each have a vote. If we disagree, I, as the primary custodial parent, get a tie-breaking vote. So she and I know that for all practical purposes, she has no real legal custody. I make all the decisions, and I just ask her in case she knows something I did not consider for my child. So if you request legal custody for medical, educational, or religious decisions, make sure you request ultimate legal decision-making, and not just the ability to provide input. Otherwise, over the long term, your input can easily be ignored. Comments. Before we discuss restraining orders at this point, I want to get some viewer comments. If you are a father in family court, what is your experience like? Do you think you are being treated fairly? Share your comments below on this video so that other users can learn what to expect. Let's talk about orders of protection. There are generally two types. The first is a no contact or stay away order. The second is a no harassment order. Different states use different names, but they are all similar. In addition, a restraining order can be against the other parent, or the restraining order can be to protect the child from one parent. Before we even discuss this, if you have an order of protection against you, you need to read it immediately. Every state is different, and every order can be different. You need to know exactly what your order says you are not allowed to do, even if you know the order of protection is based on false allegations, and you know you will ultimately prove your innocence, the judge is still the most ignorant person in the room, at least until we have a real trial with real evidence and facts. Data has recently been released showing that around 70% of restraining orders are dismissed as unfounded. But until that happens, as the king or queen of the courtroom, the judge will not let people violate his restraining orders. Otherwise, he looks weak. If you violate a restraining order, you are very likely to be punished severely, including jail time. So do not, I repeat, do not violate an order of protection. We will go through other strategies to get you on a path to victory and block the judge from just blindly rubber stamping the mother in his final decision. But violating an order of protection is not part of our strategy. It will only undermine us. Let's get back to the two types of orders of protection. If you have a no contact or a stay away order, it generally means that you have to physically stay away from the other person by 100 yards, for example, whatever the order exactly says. It may also mean that you cannot contact the other person by email, phone, text, etc. If you have a no harassment order, it generally means you cannot assault, stalk, or harass the other person. But it does not impose a condition that you have to stay away by 300 feet, or that you cannot call or text them. Again, you have to read it. Many of the things you are prohibited from doing are illegal anyway. But the point the uninformed judge is trying to make is that you are on notice not to do these things. So if you do them, the judge will punish you harder. There are a couple of things to consider strategically for your life and your custody trial. First, you yourself need to file for an order of protection if the mother has assaulted you during the relationship, if she has pulled weapons during arguments, if she has thrown things at you in anger, if she destroys your personal belongings, if she insults you in front of the kids, or if she verbally assaults and insults you in tirades that last for hours. Many people in the court system tend to think an order of protection is issued for mothers against fathers, and that only fathers can be the violent one, and only mothers can be the victim. This is extremely incompetent thinking. In reality, the Centers for Disease Control, the CDC statistical data, reveals very clearly that both men and women are victims of domestic violence. It's not just women. I have no doubt you will encounter people who think of domestic violence as if only the woman can be the victim. But it does not mean that you are not a victim of domestic violence. It means that the other person is an idiot and gender biased. So it's important for your sanity to recognize these people are totally wrong and you are not crazy for speaking up. In addition, there are many men who excuse violence committed by their partner, and they think that they just have to suck it up because it's part of life. However, domestic violence, even if it's committed by a woman, is 100% unacceptable and criminal. There is no shame in having a woman assault you. She is the one with the anger management problem, not you. It's her shame. And it is certainly not in the best interests of the child to be raised by a mother who engages in domestic violence. And appellate courts have ruled this. So while you are in court proceedings, this is not the time to try to sweep her violence under the rug. In your case, whether or not the mother has filed an order of protection against you, if she has committed acts of domestic violence against you, then you should file a petition for an order of protection. A key part of your strategy will be to hold up her bad actions for everybody to see. You are the expert witness and all-star MVP of your case, and you alone are responsible for exposing this. If you do not hold up her actions for everybody to see, then you are increasing the odds that the family court judge is going to rubber stamp the mother for primary custody, and you will become nothing more than an alternate weekend parent on top of being a victim of domestic violence. If you have not filed for an order of protection, and you are a few months into your proceedings, you can still file a petition for an order of protection. You run the risk that the judge or the mother's lawyer will complain to you and say, "You should have done this a long time ago." Yep, that's what they sound like. Or, "You are only doing this for revenge." But your response to that is simple. First, I have the right to petition the court. Second, there is no requirement that says I have to file for an order of protection the day after she assaulted me, or within 3 months of when we go to court. I can still petition the court during the proceedings. Third, you can explain that you did not know you had the right to file a petition for an order of protection, and only now are you learning you have that right. So now you are exercising that right because you still fear for your safety, even though you live apart. Fourth, you can explain that when the mother filed for a petition for an order of protection, she made allegations of your abusive behavior. The judge almost automatically gave her a temporary order of protection with extremely limited evidence and testimony. And judges hand out these temporary orders like they are going out of style. So when you, the father, file your petition for an order of protection and make allegations against her, it is only fair that you also be issued a temporary order of protection. A judge would be gender biased if they gave a temporary order to the mother, but refused to give a temporary order to the father. So you can also point this out to the judge. But, of course, you cannot publicly accuse the judge of being gender biased, because the judge will freak out, get defensive, and hate you, even if it's true that they are being gender biased. What you do say is that you and the mother should be on equal legal footing if you are both making allegations of domestic violence, and that before a trial to fully investigate the matter, you both have an equal right to a temporary order of protection based on allegations. And if her alleged behavior is equal to or worse than your alleged behavior, you should point out to the judge these facts very clearly. To establish, you need a temporary order of protection against her. What do you write about in your petition for an order of protection? When you fill out your petition for an order of protection, you will list examples of the mother's abuse against you or the child. And you may request an order of protection on behalf of the child against the mother if the facts warrant it. In the petition, I want you to list as many examples as you can of her abusive behavior. For example, write about each occasion separately where she assaulted you, punched you, or kicked you. And don't be vague or cryptic, but write the details. Write about incidents where she was throwing objects at you, or where she was verbally abusing you. It helps to talk about the frequency of these abusive behaviors, such as 3 times a week for 2 to 5 hours at a time, like it happened to me. Just be truthful and reflect reality. If you filed police reports against her, definitely add those to the petition. As a strategic side note, police reports containing your statements might not be admissible later during trial because they might be hearsay. So it's important that you insert those police reports into your petition at the start. If the police reports are not admitted later at trial as evidence, then the judge won't see them. But if you put them in your petition when you file it, then the court can't help but see the police reports, even if they are not admissible later during trial. Strategically, your prior complaints to the police help show your accusations are not new and not just for the purposes of a custody trial. If you have pictures of your bruises or injuries, or if you have medical records where you were treated for injuries she caused, you add some of that to the petition. If you don't have any evidence that she was punching you, that's okay. There are 2 types of evidence. One is physical evidence, like pictures, police reports, and medical records. The second type is your testimony and witness testimony. So even if you cannot prove it with evidence, you are still going to testify verbally about it later during the trial. There's another reason for you to add documentation, police reports, pictures, and detailed stories to your petition. Judges hand out orders of protection in favor of mothers like they are going out of style. However, you are entering a hostile environment where the courts treat fathers like second-class citizens. So when you file a petition and you have detailed claims of her violence, as well as police reports and pictures, you are making it very hard for the judge to just ignore reality. You are blocking the judge from engaging in the status quo of just blindly rubber stamping the mother. This is a key part of your tactical strategy to overcome the gender bias of family court. Secondly, I want you to think about if and how you communicate with your child's mother if she has an order of protection against you or vice versa. Let's assume you are allowed to email and call her and meet her in person. I will give you two completely opposite scenarios to consider. There's no correct answer because it depends on your relationship with the mother and her integrity. Both of these scenarios involve whether or not you have discussions with the mother outside of court so you can negotiate a settlement for custody of your kids. In scenario number one, you choose to speak or meet the mother in person to negotiate settlement options. The positive of this scenario is that you can have real discussions to come up with real solutions for your real problems and get out of court. That's an ideal outcome. However, the problem is that if she has already filed false allegations, then she is the kind of person who will possibly make more false allegations against you. And if you meet with her, but she then uses that meeting to allege you harassed her and violated the order of protection, then you are in more trouble. In scenario number two, you choose to never meet her to negotiate a settlement of your case because you are too afraid that she will accuse you of violating the order of protection. This is a very valid concern. The problem with that is that if you and the mother are not speaking directly, and you both have lawyers in between you, then all of these people will keep the trial going and keep charging you tons of money. I found that family court lawyers are much, much worse than most other professionals at helping mediate a real solution to real problems. So if the lawyers are between you and your kid's mom, you might be losing any possibility of settling this without bankrupting yourselves. So you are damned if you do and damned if you don't. However, I want you to understand the benefits and risks of each scenario so you can make an informed decision about how you should proceed. Let me give you an example in my case. Between years 1 and 2 of court proceedings, the mother and I still had temporary orders of protection against each other. She and I met with a child psychologist who mediates custody issues. The mother and I physically went to meet with him and his team. I was deathly afraid she would come up with some new story about how I harassed her during these mediation meetings. To manage that risk, first, I always carried a paper copy in my pocket of my order of protection against her. If the police were ever called, I could instantly present it and tell the police that this is not a case where they are supposed to blindly rubber stamp the woman, and I have an order of protection to prevent her from harassing me with false allegations. Secondly, anytime the mother and I arrived in the mediator's offices, I made sure there was never even 1 second where we were alone in a room or the hallways. I made sure I was always standing next to another human being, so the mother could not create new false allegations. You have to proactively protect yourself because nobody in the system will protect the father. Let's talk about temporary orders because there's an enormous difference between a temporary order versus a final order. When you first go to court, the judge has to issue an order of custody or an order of protection temporarily while these proceedings go on. After that first day, you will probably have court appearances about once a month, where nothing gets changed and there is no intelligent analysis in court about anything. Ultimately, after 1 or 3 years, you will finally have a trial where the mother and the father present their evidence and testimony related to child custody and orders of protection. After the trial ends, that's when the judge will make a final order on custody and a final order of protection if that is warranted. In my state, a temporary order is just a temporary order, and it cannot be appealed to a higher court. So you are forced to live with it, unless you can get that judge to change it. Only once there is a trial and the judge makes a final order on custody or an order of protection, Only then can you appeal that final order to a higher appellate court. You have to look up your own state laws on Google to see if that's how it works in your state. And if that's the case for you, then you have to realize that the temporary orders are going to be in place and probably not changing until there's an actual final decision after the trial. And that's why you want to argue adamantly on day one for 50-50 custody or primary custody, because that arrangement will likely stay in place until trial is over, and you don't want 2 or 3 years to go by where you are just an alternate weekend parent and your child's life is passing you by. And that is also why I want you both to have orders of protection against each other, instead of being in a scenario where only the mother has a restraining order against you. A restraining order requires a person to be on good behavior or they risk jail time. If there's only a restraining order against you for a long time, then that greatly increases the probability that she will insult you or harass you to bait you into violating your restraining order. It's harder for her to do that if the restraining orders go both ways. In my introduction video, episode 1, I laid out the series of topics we will be discussing. The next topic in this docuseries will be choosing an attorney and minimizing spending, or going pro se. These might be the darkest days of your life, and I'm making these educational videos to help you navigate this nightmare. If you subscribe, I can get you updates when I post more videos in this docuseries. If you find this information helpful, then please like and subscribe and share with your friends who are all in a similar situation. If you like, subscribe, and share, it will also help the YouTube algorithm get this message out to more fathers in our position.